这是他们会在群里说吗？
不知道。
我问一下。Okay. Yeah, welcome everyone to our live today. So while waiting for others to join, we will start formally around 5:05 Pacific time. So that will be around 7 minutes from now. So on our screen right now is the agenda. You guys can give it a watch, and we will start at precisely 7 minutes later. Yeah, welcome everyone who joined our virtual workshop today. So we will start around 5 minutes from now. So if you are in the chat, you can just type out where you are hailing, where your company is based at, so we can kind of interact with you guys virtually. So for people who are joining right now or just joined, feel free to type out where you're hailing from, where your company is based at in the chat. So we can kind of get you know where you guys are from, and we will start 4 minutes later. I saw people are typing Bay Area so far, so all of comments are saying they're from Bay Area. Is there anybody who are not from Bay Area? Happy to see you guys as well. Hi, Garrett. Hi, ZYXAI. Hi, Kidney. Welcome to our session today. So for people who just joined, we will start at 5:05 Pacific time. So that's 3 minutes from now. And Right now, we're just doing a greeting exercise. So for whoever just joins, just type out where you're from so we can get to know a little bit about you guys. Hi, Pamela. Yeah, greeting from California. Yeah, I'm personally based in Houston, so probably the only one not based in California right now. Yeah. I would prefer us to join YouTube or LinkedIn. Either one. We are live on both. Yeah, YouTube generally works a little bit better because we can see the comments live, I believe. LinkedIn typically has like 1 to 2 minutes delay. Yeah, a lot of people from Bay Area. Hello, hello for people who just joined. We will start around 1 minute from now. Countdown 1 minute. Do we have anyone in the chat room right now who are not from the Bay Area or California? Excited to see you guys as well. Sure. So I think it's 5:05 precisely. So we can get started. So for people who just joined, our agenda for today is from 5 p.m. to 6 p.m. will be our formal presentation. We will go over a couple of issues that you guys raised via Luma. We will go over common issues in establishing a startup, the share structure and IP protection, cap table example, venture financing instruments, what is safe, pre-money safe versus post-money safe, components of a term sheet for equity financing, investors' preferential rights, and also startup compliance. And of course, we will go over not only these issues, but also others as well. And to give you guys a window for Q&A, we will do audience Q&A from 6 p.m. to 6:30. And for anyone who has any questions during a part of our first 1 hour's presentation, feel free to just type in the chat and I will note down these questions and ask Ms. Liu, our guest speaker, during the Q&A. So don't worry, we will take as much as of your questions as possible. All right, so before we formally get started, I'd like to give a brief intro of our guest speaker for today. So Ms. Liu is the founding partner of Magstone Law LLP and a seasoned corporate attorney with 20 years of experience representing US and China private and public companies, as well as financial institutions in a variety of M&A, joint ventures, and venture financing transactions. So prior to founding Magstone Law, she worked for a major international law firm in its Palo Alto, Los Angeles, and Hong Kong offices. She also frequently mentors and lectures at institutions like Stanford and Santa Clara Law School, as well as various incubators and accelerators. So she is the perfect lecturer and mentor for everybody who joined today. And without further ado, let's get started and welcome, Ms. Liu.
Thank you, Jack. Good afternoon, everyone. It's a great pleasure to be here to share some of my experience and knowledge regarding startup formation and venture financing. I understand that there are a lot of founders or who people interested in setting up their company joining today's session. So I wanted to share with you regarding, what you need to pay attention to regarding startup formation and, future venture financing. And if you are investor looking to opportunities, I think that's also same kind of knowledge you may want to know when you talk to startup founders. Probably let's start right now. Next page. When we talk about venture financing, the first thing is how you wanted to establish your startup and what things you wanted to know before you set up a company. The first question we encountered most oftenly is what type of companies I wanted to establish and where shall I set it up. The rule of thumb, maybe a lot of founders already know, is Delaware C-Corp. And the reason for Delaware, a lot of people say Delaware has no state tax, and is that for tax benefits, so we set up in Delaware. Is that true? The answer is no. The real reason for setting up a Delaware company is really because the Delaware company law is very advanced. They have a lot of precedents, especially when you have a shareholder dispute or claims. They have a very perfect system to resolve the shareholder dispute, and their law gives the maximum accommodation for founders and investors to realize their agreement. They don't really have that many mandatory rules to restrict people from structuring the company. Instead, they give a more accommodation for that. That's why Delaware become a very, very popular state for people raising financing. And especially if you just started your company and you set up it elsewhere, you may encounter a lot of investors actually require you to reinvest, reconvert your company to a Delaware C-Corp. That's partially the reason, because investors, they really know the Delaware law. They know how they can structure the company, and their lawyers very familiar with the Delaware law as well. So as a corporate attorney, you know, like in California, you may not know, Massachusetts corporate law. You may not know Oregon corporate law, but you have to know Delaware corporate law. Second of all, you may inquire, what type of company shall I set up? The most common company format is C corporation, S corporation, LC, and limited partnership. So for a company you want to raise fund, the most common is C corporation and LC. The reason is for those two companies, there's no limitation on what kind of shareholders they could have. For example, S corporation, they are more restrictive. Only a US person or people with a green card, they may be the shareholders. A foreign person or entity cannot be shareholder of S corporation. That greatly limited the application of the S corporation. For C corporation and LC, the major difference is tax. So the reason is LC, you can elect for different tax format, but if you don't do the special tax election, LC usually treat more like a partnership or a disregarded entity, which means that entity itself does not need to pay the tax. Who's gonna pay the tax for LLC? The shareholders. So which means if a venture capital firm investing in an LLC, what's gonna happen? That means your investor as a shareholder of the LLC, they have to file tax annually because of they invest in you, which cause a lot of trouble. Because like most of the venture firm, they are also formed in a format of LC or partnership. So if they, as shareholder of the LC, need to file tax, what does that mean? Like all their LPs means their investors will also need to file tax. That's why LC become less popular for the venture world, especially for a high-tech company, which requires a lot of funding. And C corporation would be the ideal format, because C corporation, they file the tax on its own. Unless it distributes dividends to the shareholders, shareholder doesn't have to worry about filing tax because of their investing in the C corporation. So I saw some of the audience raise a question of how an LC can be converted into a C corporation. In Delaware law, they actually allow LLC to be directly converted into C corporation if the LC is also a Delaware LC. If your LC is converted into elsewhere, for example, California law allows the LC to be directly converted to Delaware C corporation as well. The procedure is comparatively simple. You have to file in both states. And basically, we call it a statutory conversion. So it's not a very complicated process, but you do need a few $1,000s to process that request. Talking about corporate governance, once you set up a startup, how are you going to manage the startup? Who's going to make a decision for the startup? For C corporation, for example, they usually have 3 layers of corporate governance: the shareholder level, the board level, and the executives level. The shareholder level is more like owners. They own the company. So what they going to do? They mostly, their function limits to, they're going to elect who are the board members. And what the board do? The board is actually the brain of a company. They make all the major decisions for the company. Therefore, for startup founders, you wanted to have the control of the board. That means you still can control vast majority of the decisions in the board. And for executives, they are more like they can enforce whatever board authorizes them to do. Especially for CEO as a natural authoritative person to sign documents on behalf of company. So executives do the day-to-day work. But the board, remember, that's still the key for the corporate governance. A few frequently asked questions I wanted to mention here. They said, when shall I set up my company? A lot of founders are still working for another employers. So when they wanted to set up their company, first of all, for the IP protection purpose, you don't want it to set up a company before you even resign from your current job. That's a rule of thumb, because you wanted to avoid your employer chase after your startup because of IP violation. I will explain in more detail in later slides. Second of all, when shall I set up your company? When you wanted to sign a contract. Because when you set up a company, if you use your own name, that basically you put your personal liability upfront. You put your personal assets at risk. Why we wanted to set up a company? To limit your personal liabilities. A company is responsible for this agreement instead of you as an individual. And when you wanted to set up a company, when you already talked to a potential investor and the investor said, we're going to send you the term sheet if you want to start right now. So that's the time you may want to set up your company and prepare for the financing. Next, a lot of people see vesting and 83B when setting up the company. What does that mean? So vesting is a mechanism if a startup has more than 2 founders. So if you have 1 founder, vesting may not be necessary. But sometimes some of the founders still choose to do a vesting for a reason I can explain later. But in general, vesting is helpful when you have 2 or more founders. For example, Jack and I, we set up a company today and we split the shares 50-50. But after working hard for 3 months, Jack said, oh, I'm sorry, for personal reasons, I can no longer pursue this venture with you. So I need to quit. what shall I do? The shares already be issued to Jack, and Jack disappeared. He doesn't want to cooperate with me to return the shares the company issued to him. So I'm still the 50% owner, but I have to deal with all the work. Is that fair? This happens every day in your venture business, in your startup. So vesting protects me as a remaining shareholder's interest. So both Jack and me, we're going to sign a share restriction agreement, which provides that we have to work for the company for at least 4 years. And the first year has a 1-year cliff, which means I have to work for 12 months in total in order to have 25% of the shares issued to me get vested. What means vested? Vest means company cannot purchase back my shares, or even they wanted to purchase, they have to use fair market value. But if the rest of the shares, I only work for 1 year and then I left, the rest of the 75% of shares will be unvested. What happens when the shares are unvested? The company can repurchase those unvested shares at original issuance price. When you initially purchase the company shares, you probably spend $1 for all the shares you got. So that means company can spend almost the nominal price or no money to repurchase back all Jack's shares. That indirectly protect my interest as a sole shareholder working for the company. So that's how vesting works. Vesting also works when the investor investing money in the company. Think about this way. The founders barely put any money in a company, but who's going to put the money? Investors. So once investor put the money in your company and you said, okay, I left, what the investor going to do? Money already in your pocket. How can I protect my assets? Vesting. So vesting not only protects shareholders on each other, also protect the investor investing in the company. 83B. If talking about vesting, then you have to talk about 83B. What's 83B? It's a tax election that helps the founder's tax perspective. Because how you pay the tax for your shares, usually if you pay your shares at fair market value, you don't have any tax. But if your shares are subject to vesting, when they consider the fair market value, then consider your shares of fair market value at the time vested. So even you paid $1 for your shares at the beginning of the company, because your shares vested 1 year later, if you don't file 83B, the IRS will treat the fair market value as the time they vested. That means that you have to pay that much of fair market value in order to without have a tax consequence. If you already file 83B, they will treat at the time when you pay the $1, you already pay the fair market value. And in the future, when the shares increase its value, it's all capital gain tax instead of income tax. So the capital gain tax rate is much lower than the income tax rate. That's why 83B is critical. And remember that you have to file 83B within 30 days after issuance of the shares to you. So there's a timing issue. Some of the founders may backdate their documents, but 83B, remember, because of the timing issue, you really don't have much choices. Thirdly, can foreigners be shareholders? Can students be shareholders? The answer is all yes. Remember this. What are shareholders? Shareholders are really owners of a company. If you are owners, you can own an asset. You can own a company. Company is an asset. So even foreigners can be shareholders. Students, no problem. Are there any requirements for executives and directors? Some of the executive directors, they are students here. They don't really have a work visa. They are working here is there any qualification requirements for being a company's executives or directors? Under the corporate law, there's not much requirement actually. Anyone could be executives and directors. However, because some of the people, they are still students, they may not have the work visa or they may not qualify to work in the US. This is especially true for foreign students in the US. So in that circumstance, you may want to double check with your immigration lawyer if you wanted to act as executives or directors of your company. Because if you don't have work visa, you're not supposed to work for your startup in the US. However, if you located in China, you're not actually residing in the US. Can you be a US startup's executives and directors? The answer is yes. Why? Because I just mentioned, corporate law, we don't really have a restriction. That's why you can be, but what the restrictions are, immigration law. Lastly, can shareholder information be publicly accessed? For some of the jurisdiction, for example, China, all the shareholder information are public. So if people go online, they can search, oh, company B or company A, who are the shareholders and what the shareholders' information are. You all can be public accessed easily. But in the US, it's confidential. A lot of you may heard the recent BOIR filing, which is the Department of Treasury. They require most of the companies set up in the US to file their beneficial owners information. However, this rule got a lot of protest and was banned by a lot of courts. Why? Because people feel they intrude the privacy. And that's a tradition in the US. Like shareholder information, you don't even need to share with the state. So when you set up the company. So how you establish who are the shareholders of a company, you have to hire a lawyer to draft the agreement, or at least you have to draft the agreement to purchase the shares in order to indicate who are the shareholders. That's why the internal documents are critical. And you are the one responsible for the internal documents. But the state or the government, they actually don't have such information. Even for the Department of Treasury, even they ask for beneficial owners information, such rule has been suspended again. You may notice a lot of newsletters keep on saying, oh, now it's subject to filing, and now we suspend again. So it's back and forth probably 5 to 6 times already. So recently it's probably finally put down in moot, meaning that at least temporarily no such filing is needed. But even so, like Department of Treasury is filing, even you filed it, that information is not public accessed. So anyone wants to know what your company shareholders are, they have to ask you. Okay, next.
Yeah, quickly before Ms. Liu continue, I know you guys are already typing in questions in the chat. We will be answering those questions, but only after the end of the presentation, which ends at 6 p.m. Pacific time. So if you guys have any questions, feel free and please do type in the chat. We will be answering them, but just not right now. It will be answered all during the final 30 minutes Q&A section. Thank you. Yeah.
Thanks, Jack. Second slides, I want to quickly touch upon share structure and IP protection. So a lot of founders going to ask, what's my share percentage are? Well, that question is kind of big and not really a legal question because different investors are going to say different things. Some of the investors, they felt like if you are co-founders, you want to treat each other fairly and you wanted to make sure each other are comfortable, not currently, but in the long run as well. So there is certain assumption who come up with this startup ideas and who gonna work part-time, who gonna work for full-time. and whose IP will be important for the development of the company, what's your contribution would be, and is that position replaceable? So there's a lot of question involved when you determine the share structure. So that's not really the centerpiece I want to talk about here. But from the legal perspective, how do you want to set up your cap table and understand your share percentage? I'm going to show you in the cap table how you usually split the shares between the founders, how you set up your option pool, etc. Second question, how do founders' shares and dilution work in early rounding funds? So you may notice for venture financing, the key is investor invests a lot of money in you, but they only take a minority percentage of your capitalizations. For example, for a seed round, they could invest $1 million and get 15% of your company. And for A round, they got another 3 to 5 million to get another 20%, and B round additional 20 to 30%. So every round there's a dilution works, and the dilution usually happened pro rata to all the existing shareholders and your stock incentive pool. For a stock incentive plan, this is a plan usually used to award your executives, your employees, and your outside advisors. Why we have the stock incentive plan is because if your plan conform to the IRS rule, then your plan can issue both incentive stock option and non-incentive stock option. The incentive stock option only issued to your employees. Non-incentive can be issued to both employees and outside advisors. But the good part is the issued options, the recipient, they don't have to pay money immediately. Knowing this, in the US, if you want your company issue shares to anyone, that anyone has to pay the fair market value to the company in order to purchase the shares. So for example, when the company just set up, the founders have to pay minimum nominal value they decide to exchange for their shares. For example, $1 for 1 million shares. However, when the company start growing, when the company got more input, more money into it, more revenue, or more IP development, the company's value grows. So your company shares no longer $0.0001 per share. They could be 50 cents per share. So by the time, if I still wanted to give you 1 million shares, how much do you need to pay? A bunch. So if you don't want to pay the fair market value for the shares, what are you going to do? Stock options, which is a very good way for people who don't want to pay the money for the expensive money for a startup shares, because you don't really know the future of startups. There's a large percentage a startup could fail. If you already put like a $100,000 as an employee who doesn't have much earnings and for that shares, you probably feel, okay, all my $100,000 gone because the startup failed. So stock option is a very good middle ground. When company issue your options, that means once the options are vested, then you can exercise your option and become a shareholder. That means you can pay the money later when the shares are vested. So options give a lot of room for people who don't want to pay upfront. And stock option pool, they usually calculate within the cap table. I will show you later, so you have a better idea. And then the last point I want to touch upon is IP protection. So when a lot of founders are asking, how can I protect my IP when I talk to my co-founders or potential key employees or investors? The key is NDA. So you wanted to sign an NDA we call the confidentiality agreement or non-disclosure agreement to protect your IP. So whatever I say to you regarding my IP, you have to keep it confidential, and that usually lasts for years. And for trade secrets, it's probably lasts forever. So that helps the company to protect the IP. So that's the rule of thumb. Second of all the employees, executives, once they join the company, you may want them to sign an agreement called confidentiality and IP assignment agreement. What that agreement say? Basically, whoever working for the company, all the confidential information they acquire because of this position, that they have to keep that in confidential. Second of all, when they join the company and work for the company, every IP they generated from their work belongs to the company. That's how the company's valuation become increased. It's because everybody's day-to-day work. But if you don't have such agreement, the employee, after leaving the company, they could say, this is an IP belongs to me, and that could, increase the risk for the company who that IP belongs to. That's also why I mentioned earlier, some of the employees are working for big companies, and they probably already signed this agreement. Whatever they do during their employment the IP belongs to the companies. So if you don't resign and already start your company, then whatever you create for your startup, whether that IP belongs to your formal employer or belongs to your startup, that become a question mark. That's why a lot of investors, they prefer at least you resign before set up the company to make the line very clear. Thirdly, a lot of startup was created by professors or professor working as an important advisor or co-founder for a company. For those IP, mostly it belongs to the university. So your company, in order to, without infringing other people's IP, you may want to negotiate a licensing agreement with university in order to use that professor's IP properly for your startup. So licensing is an important piece for startup using university's IP. Next page. In the next page, I wanted to show you when you set up the company. When you set up a company, usually there's an important piece called a certificate of incorporation in Delaware. In California, it's called articles of incorporation. So what that certificate actually say? Most important piece is what's your authorized shares of authorized shares. So authorized shares is what's the maximum shares a company can issue to its shareholders. So it doesn't mean anything. It's only mean this is the cap. This is how much you can issue. You can't supersede this number. Once you supersede, you have to file additional amendment to the certificate to the Secretary of State in order to issue more than authorized shares. What is issued stock? Issued stock is what the number of shares you actually issue to your shareholders. So for example, a company has founder A and founder B. So founder A got 3 million shares and founder B got 2 million shares. So founder A, without the option pool, actually have 60% of the company shares, while founder B has 40%. Why? Because their capitalization is not 10 million. It's not authorized shares. It's the total issued stock, which is 3 million plus 2 million. Now, the company said, we need to hire more advisors and we don't want to directly issue shares to the advisor. What shall I do? Okay, setting up an incentive plan, which is the option pool, in order to issue stock option to your advisor. So how big a size of my option pool is? Okay, let me set 1 million here. So once you set up the option pool, the company capitalization become 5 million plus 1 million, which is 6 million. So now when you calculate founder A and founder B's share percentage, it becomes 50% and 33%. So who steal the rest of the share percentage? The option pool. That's why when a company just set up, you wanted to pay attention how much you wanted to set up your option pool, because the option pool dilutes all the founders. So how big your option pool is based on your needs. You don't want it to make it too big, because for a period of time, you will be diluted too much at the beginning. A lot of investors, this is a point for investor. A lot of investors, they only tell the company, okay, I put $3 million to your company, I'm gonna get 10%. But they don't talk about the option pool. No, that's not a good idea. When investor invests in company, in order for them, like, I don't want to get 10%, and immediately after I invest the money, the company said, now we wanted to expand our option pool. So now you immediately do it to 8%. That's not what an investor wants. So smart investors, they always tell in the term sheet saying that I want to make sure before I invest, you option pool is at least 10%, so that I don't get immediate dilution after investment. Okay, next page.
Yeah, just before we continue, I want to say again that, thank you for people who ask questions during the chat. We will be answering those questions at the end. And I would actually encourage people to ask questions when Ms. Liu is talking about each topic. Because if you have that question, just type it out in the chat, and we'll be answering those questions in chronological order. Meaning that if you raise the question earlier during our presentation today, we'll be answering those questions earlier. So just feel free to type out your questions in the chat whenever you feel. Ms. Liu, please. Yeah.
Okay, so this slides of cap table actually show you when you raise fund from an investor, how your cap table gonna look like. So here the investor gonna to get preferred stock. For example, Series C, the preferred stock, or Series A, preferred stock, or whatever, they're not gonna take the common stock. Why? The mechanism of separate out common stock with preferred stock is preferred stock by its meaning have preferential rights. Because when investor invests a big amount of money in a startup, they are still minority shareholder, remember? For example, if they put $3 million in your company, they only take 10% of your shares, or even 20%. But what 20% can do? Nothing. If they don't give him any preferential rights, the investor cannot decide anything. Remember, who gonna to elect the shareholder, the board, the shareholders. So because they are only 20% shareholders, they don't have a say. Majority of the shareholder gonna decide who the board is. So that means if the founders still hold a majority means over 50%. If they still hold 50% of the shares, they can elect the board and they can decide everything happens to the company. Then investors' money have no protection. It's all up to the founders' moral standards. Can investor bear with it? Yes, with good people, but mostly no. But this is a commercial world. We need to be fair to everybody. So now they create this preferred stock in order to make sure the investors' money is protected. What prefer means? That means, for example, you need to make sure I can designate a board member to the board, so that whatever happens, I need to know. And for some of the matters, I even have veto rights. So if the company want to increase the CEO's salary for 3 times, and I can say, oh, no. That's a waste of money. I wanted to save money for the company's working capital. I don't want to spend money to reward the CEO. So that's preferred stock 4. In the cap table, founders could, when they just set up the company, said, Ms. Liu, if I wanted the preferred stock, the first round preferred stock, to get 14% of the company. So shall I reserve the preferred stock at the beginning of the company? No, the answer is no. You don't usually reserve the preferred stock at the beginning when you set up the company, because that time mostly, even you have a term sheet, but that term sheet must unsigned. So you don't really know what the preferred stock will be. So when you usually need to change the authorized shares, it's when the near the closing of the preferred stock financing. Because right before you issue any preferred stock, you have to add those preferred stock to the authorized shares in your certificate in order to issue it. So when you need to change your certificate, right before the closing of the transaction. So here, the cap table, you can see once the investor came, they put, for example, they got 1 million Series C, the preferred stock. Then that further dilutes founder A, founder B, and the option pool. So everybody's share percentage changed again. So remember that a lot of founders, when they talk to a potential key employee, I said, oh, I'm going to give you 2% of my company or 1% of my company. And they even write it out in your offer letter. Is that a wise option to do that? The answer is no. You will try to avoid put a percentage of shares in your offer letter, because once it's writing, if it's not writing properly, it has a problem, because you don't know, probably tomorrow there's an investor investing in your company, so everybody's share percentage got diluted. So before the money comes in, that 2%, compared with after money comes in, that 2%, it's totally different thing. So you wanted to put exact number of shares you're going to award it to the employees instead of put the share percentage. So that's the key. Next. Now we finally into the venture financing section. So in the current venture financing world, there are 3 different types of venture tool for investors and companies. The first one is convertible note, which is very popular in the past before the SAFE arise. Convertible note mechanism is like this. The investor is more like your creditors. They lend the money to you. And if the company have a qualified financing, means comparatively big financing, then the convertible note can be automatically converted to your next round's preferred stock. They're going to share the same rights as the next round. On the other hand, if the company didn't go through any qualified financing, instead they have a small financing, or by the maturity date, means because it's a loan, the loan has a maturity date. By the maturity date, you have to repay the money. So by that time, the company has to repay the money to the investor. That gives the investor some flexibility. If the company goes very well and raise a good qualified financing, yes, my money can be automatically converted to company's next round of preferred stock. However, if the company doesn't go that well as I imagined, because I have the maturity date, I can still ask the company to repay my money. So convertible notes is very popular in the past, especially for company raising small amount of money. Because if the investor only invests, for example, 300,000 or 500,000, think about lawyer fee is very important. They are expensive. So even for a small law firm, not to say big law firm, like one round of financing could go above 100,000 nowadays. So for a small amount of investment, you don't want to spend that much on lawyers. You want the money to be used by the startup to develop their company, develop their technologies. So convertible notes is a simple instrument. People usually spend, under $10,000 to negotiate and close convertible notes round financing. So that greatly reduces the cost and help the company to move forward. And convertible notes, because they're not gonna, the investor not gonna immediately get a preferred stock. They don't have to negotiate with you what kind of preferential rights I'm entitled to. So that reduces the negotiation time as well. Second of all, convertible security. I put safe case, there is an early year. Safe is not that old. Safe is a kind of new instrument. They created by Y Combinator a few years ago because they want to simplify the financing process. Even convertible notes, they feel it's a little bit complicated because the investor has so many options. They can even demand the money back. And for startup, they have to worry about, oh, by the time I didn't raise finance, I have to repay the money. They give founders a lot of unsecureness. So in that circumstance, SAFE come out. What's the SAFE? You see, I also put a convertible here. That's why their mechanism is very similar to a convertible note. The only difference between SAFE and note is that SAFE doesn't have maturity date. SAFE doesn't have interest because SAFE is not even a loan. So for investors, once they put the money as a SAFE holder, they don't do anything. They're not even shareholders. So when they become shareholders, after this SAFE be converted to company's next round of equity financing. And remember that I mentioned that for convertible notes, there's qualified financing. So that means you have to have a bigger round in order for the convertible note to automatically convert. But for SAFE round, as long as you have an equity financing, then they have to automatically convert. So that's more pro the company and the founders and less advantage to investors. In the early years, the Y Combinator has SAFE called pre-money SAFE. That's even more flexible. You can give investor A type of SAFE and give investor B another SAFE with different valuation cap, different terms. And later on, they feel pre-money SAFE is too much pro company side. So they got a more balanced version. We call it post-money SAFE. So that's currently available online. You can download. KISS is another type of convertible security that was issued by another incubators. However, KISS was not that popular. I think because KISS at the beginning, they were more balanced form, and SAFE is more popular for companies, so a lot of people start using it. But the mechanism internally is kind of similar. Last one for equity financing, preferred stock. This is we call the most common one for comparatively larger size venture financing. So if the investor put 1 million or above, I think it's okay to do a preferred stock round because the lawyer fee could range for example, from 15,000 to 50,000 for a small round. For bigger round, it really depends on the law firm. Some firm, one round I heard could go to 200,000 for 10 million or above financing. But whatever is that, the key for preferred stock financing, the key documents are these 5. So series, for example, seed, preferred stock purchase agreement, amended, restated articles of incorporation or certificate of incorporation. This is the thing I said, you're going to change your authorized shares and put the most important preferential rights in this document because this document's public accessible. So that means everybody going to know what you provide. And you're going to have an investor rights agreement that provides some other preferential rights for the investor. Voting right agreement mostly focus on how your board are going to be elected. Lastly, right of first refusal and the co-sale agreement, that's for restriction of founder sale. So if the founder want to sell the shares, they have to sell to the company first. And if the company doesn't want to buy, they can sell to existing major shareholders, i.e. investors. If the investor also don't want to buy, they can sell to third parties. But at that time, the other shareholders have the co-sale right. That means if you can sell to third parties, I wanted to tag along with you. I wanted to sell my shares as well. So right of first refusal and co-sale greatly restrict founders' sale of their assets, sale of their shares. Next. Next page. So back to SAFE, as I mentioned, the SAFE is an investment contract between startup and investor that give the investor right to receive equity in the future. And what you need to negotiate for SAFE, why SAFE is popular? Because it's a simple instrument. You can close a deal within $500 lawyer fee. And your lawyer probably just need an hour to draft the document and discuss with the terms, and you can close it. So for the SAFE, usually there are 3 types of SAFE currently available. One is only discount rate. This applies, for example, the company going to raise equity financing soon. So you don't want it to have a very low valuation cap to make your future investor not very happy. So you can give a discount rate because I put the money earlier, for example, 3 months early, you give me a 10% discount or a 15% discount. You can also have the SAFE only have valuation cap, which means regardless of how the company valuation would be. For example, next round is 10 million. This SAFE, we're gonna cap our valuation at 5 million. So that means you give a huge benefits to the SAFE holder, so they can invest in a much lower price. Or you can have both discount rate and valuation cap, whatever is more favorable to the investors. That's more beneficial to the investors. You don't have to guess. For example, I set my valuation cap as 3 million and turned out to be my next round of equity financing is 3.1. And that time discount rate kicks in and discount rate turns out to be more beneficial to investors. So that's the thing. And some of the SAFE is also called most favored nation. That means they don't really have much discount or valuation cap, but their terms will be most beneficial. So there are different type of SAFE available on Y Combinator's website, but those are the most common ones. Next page. Okay, here I just want to quickly touch upon when we talk about SAFE preferred stock. In the SAFE, you oftentimes say, okay, when I convert to the next round preferred stock, you don't actually get an exact next round preferred stock. You got a SAFE preferred stock, which means you actually still get the next round of SAFE, but you may call it, so next round called a Series Seed, and you may call it Series Seed 1 or Series Seed 2. Why that? Why that? Because the SAFE holder got a discount or the SAFE got a cheaper price to get the shares. And so even they got identical rights and privilege as next round because they paid less money for per share price. So for example, in the future when the company exit, because usually the preferred stock have the liquidation preference, which means when the company got a 100 million money after the merger and the acquisition, and the money gonna goes to the preferred stock first. And they're gonna base on the number of shares you hold in to give the money back to the preferred stock. And if you don't separate out, that means you pay less money, but the company have to pay you the full money for the Series C shares you get, which is not beneficial to the founder. So remember this, when you have a SAFE instrument, definitely put a SAFE preferred stock in it. So the SAFE holder only get a SAFE preferred stock instead of, exactly next round preferred stock. Next. Seems we really ran out of time, so I'm gonna let's go to the next page. So because I already touched upon pre-money and post-money, the only difference between pre-money and post-money is pre-money plus investment amount equals post-money. So for example, if the company is currently valued at $3 million and you got a $1 million investment, what's your post-money? Is $4 million. So how you calculate your SAFE is based on that. So if an investor said, I put $1 million in exchange of 10% of your company, that means the post money is 10 million because it's post the investment, they're gonna take 10% for 1 million. So that means the company's whole valuation after investments 10 million. So what's your pre-money valuation? 9 million, 10 million minus 1 million investment amount. So when you receive a safe as an investor, you wanted to know what kind of a safe you got. Don't just say safe. Safe has a lot of versions. You have to make sure the terms are actually what you need. Okay, next. Now we talk quickly about equity financing. Same token, pre-money valuation versus post-money. That's the differentiation. And here you notice that I said highlight that the pre-money valuation shall include an allocated, uncommitted employee option pool. This is the point, remember, I mentioned earlier. The investor don't want it to be diluted immediately after financing. That's why they require you in the term sheet that you have to reserve certain amount of employee option pool, and that pool has to be unallocated and uncommitted. Means those one you totally reserved for future issuance. So smart investor definitely put this one in their term sheet. Okay, next one. Which party? Oh, sorry. Next point. Can you go back to, yeah. Which party shall be responsible for drafting? Different jurisdictions have different habits. In Silicon Valley, it's always a company counsel drafting the documents, because who drafting the documents, that document's gonna be pro that party. You know, like because of equity financing, there are 5 major documents. Each document is above 20, 30 pages. There's a lot of details. Devil is in the details. So if the party who drafted, they definitely everywhere, every detail, they're gonna be pro company. But if you have the investor drafting the documents for you, there's a lot of details. They're gonna to be pro-investor. So when your lawyers try to negotiate down for you, it's much more effort because you're gonna spend a lot of your lawyer's time, and also without a very strong reason, it will be hard to negotiate out. So you want your own lawyer to hold the pen. Restriction to founders and key employees. This usually refers to in the term sheet, the investor will say founders have to subject to, founders and key employees both have to subject to the 4-year vesting. Remember the vesting definition I mentioned before? This is an investor kicks in. If you don't have a vesting, they're gonna put the vesting on your head, on your shares. And remember that it's not like only 4 years. After certain years, you raise another round of financing, the new investor, even your shares already vested probably 3 years, the new investor could tell you, okay, I want another 4 years because I put a new money in. I don't want you just like out of the hook. So again, you have to negotiate with a new investor what my vesting schedule is. So 4 years is not the end. 4 years is the start. Exclusivity. This is also in the term sheet of equity financing, which means once you sign the term sheet, the investor said, you can only talk to me. You can't talk to other investors. So be very careful with the exclusivity provision who you can talk to, especially no founders only talk to one investor. They try to expand their reach as much as possible. But once you sign a term sheet with exclusivity clause, which usually has, you want to be very careful what you do. The special issues regarding founders' personal liabilities, this happens to in some of the jurisdictions financing, especially for example, China, they require founder to put their personal liability with respect to the company's operations. That's very dangerous for founders. So in Silicon Valley, in the US, we never do that. We don't want to put our personal liability with a company. That's why we set up a startup, right? Second of all, redemption clause. This is a clause, although in the standard provision, it's rarely used in Silicon Valley. The reason is redemption clause is a weird clause. It provides, for example, if the company cannot go IPO or cannot exit after certain years, then the investor can demand the company to return its investment. It's called a redemption. However, think about this. Why company barely uses redemption clause? Because it's really hard to enforce. If the company is going very well, who want the company redeem my shares? Because when you redeem, the price is definitely low. But if the company goes very poor, very bad, you want the company to purchase back your investment. Do they have the money? No, they don't. So it's really hard to enforce. Plus, under the Delaware law, if your company's assets not enough to pay for those, you can't even do that. It's violate the law, because that means you put all the company assets to one shareholder, then you basically buyers to the remainder shareholders. So it's a lot of restrictions to apply this redemption clause. But I have to say, redemption clause in some other jurisdictions very popular. CFIUS. What is a CFIUS? CFIUS, a very popular concept in recent years, is because before CFIUS only arise when the company is doing M&A. When you have a change control event. So CFIUS wanted to know which foreign investor acquired my company. Are they still trying to steal my key IPs, or something could threaten my national security? But after 2018, the whole picture changed, and they invited CFIUS jurisdiction to the venture world. That means if the company is considered a TID business, which means they have critical technology or they hold sensitive U.S. persons' information, or they are related to key infrastructure, then the company become TID business. And if the fund is a foreign fund, doesn't mean that doesn't matter whether the fund is established in the U.S. It's really whether it's a foreign fund depends on whether their GP a U.S. person control it. So if they are foreign, then you might need to hire a CFIUS counsel to do analysis and see whether the whole transaction need to make the filing with the CFIUS. The CFIUS filing have voluntary and mandatory. If it's a mandatory, you can't close the deal without filing. If it's a voluntary, you can still go ahead and make the deal. And later on, but there's no guarantee that CFIUS is not going to initiate their investigation few years later. Sorry, I think the time's up. I'm gonna to stop here, and probably let's go into our Q&A session. And if you have any questions, welcome to raise them now.
Yeah, thank you, Ms. Liu, for this hour-long presentation. And I will repeat the questions in chronological order, meaning people who ask the first question will, I will repeat those questions first. And of course, for people who just joined or they have other questions, feel free to type in. We have half an hour to tackle all of these questions, so more than enough time. Yeah. So our first question is from Garrett Chan. He asked, any thoughts on public benefits corporation? I think that's regarding your first slide, talking about which kind of company to form. So yeah.
Yeah, public benefits it's kind of really popular concept those years. But in the venture world, we still see not as common. The reason is public benefits, they not only serve for the best interest for the shareholders, they also have some other benefits to the community, to the society, or other purpose. So especially for a company with environment concern or some other special industry, public benefits company could be a very good form, but it's less familiar for a lot of firms at this stage.
Yeah. So Garrett, if you have any specific questions, feel free to ask follow-up. We'll move on to the next one. So ZYX asks, based on 12 months cliff and 4 years vesting, if between year 2 and year 4, can the company buy back the departing partner's shares at a fair market value or original value?
So if they already passed a 1-year cliff, the rest of the shares, if they, for example, they leave at the 13th month, so all the rest of the shares are invested. If they are invested, then the company can buy at the original purchase price. Means If you buy the shares at the beginning of the company setup, which is nominal value, then the company can buy back your shares at the nominal value. They don't have to buy back at the fair market value. However, if your shares already vested, the company may negotiate with you trying to buy back your shares at the fair market value. That's a different picture.
Okay, next question from Kenny. If the state does not have the shareholder info, and for LLCs, shareholders reports tax based on the amount of shares, how does IRS keep track of the company's tax reporting?
Yeah, those information are not available in the Secretary of State website. However, when the company file the tax, when they file tax, they need to know who the IRS will know who the shareholders are.
Okay, yeah, he has a follow-up. So also, if one of the shareholders did not report tax properly, does the company as a whole take the accountability, or just that shareholder?
No. If it's an LLC, the shareholder is responsible for their own tax return. It shouldn't impact other shareholders because by its name, it's a limited liability company.
Is that the same for other forms of corporations?
Yeah, for C corporation, because the corporation itself has to file tax. So of course, if you don't file tax, especially the board member or the key executive, they may be held liable because they have the fiduciary duty to the company. They need to enforce that they have the obligation to help the company to make the filing. And for shareholders, only if they got the dividends, then they or interest, then they have to file tax. That's their own problem.
Yeah. Okay. So next question from Chen. Legal question. As a non-US citizen planning to start a food import businesses in California, do I need to hire employees with US citizenship or residency to register and operate the company?
The answer is no, you don't have to. But I mean, if the company is running in the US and you don't have any local people here, that would be difficult. So although you can set up the company, you can even be their directors and executives, as I mentioned before, so long as you don't work in the US, you can do that. But to actually run a business in the US without any employee will be kind of challenging.
Yeah. He also has another question. As a company owner or executive, under what circumstances could I still face personal criminal liability despite operating through a limited liability entity?
I mean, criminal will be too big of a range. Anything like, for example, tax fraud, everything that could be a criminal charge. That's a very big topic.
Yeah.
But for one thing, I think I wanted to remind a lot of executive directors, when a company is running, you start hiring the employees. You want to make sure your payroll tax are paid. So regardless whether your company still exists, for example, your company liquidates, but you own payroll tax, the IRS could still knock your door. Because payroll tax is not something you could, just ignore, regardless whether the company still exists. So, board member or executives, you want to make sure payroll tax is definitely paid. Usually, when you hire an employee, you wanted to run a payroll through a platform. For example, like an ADP or TriNet or Gusto. There's a lot of platform like that. Those platforms, once you register your account, they actually, once you issue your payroll, they automatically withhold the tax for you. But if you do it manually by yourself, if you're not really familiar with the US laws, you run a lot of risk. So not even worth it.
Yeah, so payroll tax is very important. Yeah. So ED Ting Shui asks, what other options are there to biotech founders if investors are not willing to sign NDA in the Bay Area?
And then don't disclose your most critical technology because you run the risk yourself. I think any decent, good venture firm, they know the procedure. Everybody sign it.
Yeah.
And you have to be very selective who you talk to. It's not like everybody is tell you, I have money, I want to invest in you. Then you should warmly welcome them to intrude in your IP. You also need to do your own legal diligence and make sure the investor is credible. What's your reputation? What's your track record? It's all very important because you are not just get their money. They are your long-term partners. There's a lot of startup didn't really end up well. It's because they attract wrong investors. Those investors, they want to, for example, kick the CEO out. They want to control the company. They have their own interest in investing company like that. And remember this, a lot of investors, they invest a lot of different companies. Some of the companies might be your competitors. So just envision that. If you tell them without signing an NDA, then they just disclose your key IT to your competitors, what's going to happen? So a good investor is the key for development of the startup. They not only bring you the money, they also bring you the resources. They bring you industry experience. They bring your other fundings in the future. But you choose a wrong one, and no matter how good your legal documents are, your day-to-day life will be very painful.
Yeah, so it's more like a two-way selection process.
Exactly.
Yeah, so Dan Fine asks, so LLC can be treated like a C-Corp, right?
Yes. Yes, the answer is yes. LLC is a very flexible type of company. So when you set up the LLC, usually they have different tax elections. If you don't do any tax election, as I mentioned, it could be if you have one person as a shareholder, could be disregarded entity. If you have two or more person, it could be a partnership. But if you elect, you can also choose elect as a C corporation. So like if you see like local, for example, I see local restaurant, local gym, you got a lot of local investors. They don't mind invest money in LC. So I do see a lot of LC financing as well, which is huge, but mostly for local investment. Venture fund, they oftentimes have a lot of LP that's from overseas. They don't want to invite that trouble.
Nina asks, what's your advice on giving advisor compensation in the form of equity? Anything to watch out for?
I mean, like most of startup, they don't really have much money. So they tend to give stock option to the advisor instead of directly issue stock. The reason is once you issue stock, you don't want to mess up your cap table. The cap table have too many shareholders. Once you host a shareholder meeting, you have to do a lot of notification. You got people's approval, etc. For advisor who don't really hold much shares, the stock option is probably the good tool to do so.
Yeah. And she also asks, typically, how do subsequent investors look at a previous equity grant that's anti-dilutive?
Rarely anti-dilutive. That's why I mentioned that if you have a round of financing, usually all founders and your incentive pool got diluted naturally. Rarely you see a non-dilutive shares, except for universities. Some of the universities, they also accept your royalties or upfront license fee. They also said my 4% would be non-dilutive until a certain time. So that's kind of common.
Yeah. So I guess that's all of our questions. But for anyone who's in the room and you still have any questions, or you have like questions, follow-up questions to Ms. Liu's response to your previous questions, just drop in the comments.
Yeah, just a few words to startup. Like setting up a startup is a big venture. I mean, it's always combined with a lot of sweats, a lot of efforts, and founders. You have to keep in mind, once you start this venture financing journey, you can be partially legally trained. You have to, because you don't want to. I saw some of the founders, they really focus on their operations and they totally have no clue about those legal terms. But actually, legal terms could, restrict a lot of companies' operations. And later on, once you had those things, you start realizing, oh my God, what did I give it to investors? So I think for founders to have some legal training and good guidance from your lawyers, very critical. And you wanted to find a lawyers who are willing to talk you through all these points. Some of the founders, they only speak with, for example, the big firm, they offer a very good package for startups. But if their partners are not willing to talk to you about your financing, they have the junior lawyers talk to you. I think that's not really beneficial to startup, especially at the beginning when you just start learning all this mechanism. You want to have someone to walk you through all these potential traps or problems, and you wanted to keep that in mind.
Yeah, thank you, Ms. Liu. So people feel free to add Ms. Liu's WeChat by scanning the QR code on the screen, or email or website. And also, if you're interested in more series like this, follow Founder Co-host LinkedIn and YouTube channel. Just typing in Founder Co-host. We have another question. So, Ms. Liu, do you have IP lawyer to recommend in the Bay Area?
Oh, I can give you the name after the session.
Yeah, so feel free to add Ms. Liu's personal WeChat.
Yeah, good IP lawyer is also very important, especially regarding your IP strategy, what you need to pay attention to, and when you don't have much money, what's your IP strategy are. So a good IP lawyer is important.
Oh, okay. We have another question. So Kinney says, say for a dietary supplement agency that sells a lot of food or supplement to be eaten, does the executive or shareholders face legal consequences if the product manufactured by an external entity is bad?
I mean, you talk about the product liability. Usually, because you set up a company, the company should be liable for all this potential lawsuit. Usually, not goes to the shareholder. For executives or directors, because they have fiduciary duty. So, what means a fiduciary duty is they have to have business judgment. They can't. They have to put the company's interest and the most important, and also whatever they need to do, they have to, as a careful or cautious people should do. So if they actually know that a product could be poisonous or bad to the consumer, they still continue the manufacture and provide to the market, they may be sued because of fiduciary duty breach.
Yeah. So Asimix asks, will filing a provisional patent help me funding, or should I file an actual patent?
I mean, it depends on your status. When the company just started, you may not really have the time to get the whole patent, because it takes time, and sometimes the patent it takes a few months, so you may not really have time. And also the budget, to write the formal IP. I think the IP lawyer, I'm not an IP lawyer, but they could charge you from 6,000 to over 10,000, and you may not really have the money. So file a provisional one to at least indicate I have this IP is important. So a lot of people I know, they do the provision first. But not, one case fits for all. Some of the founders, they already prepared for the startup for years. They already have the IP. That's a different story.
I personally actually have another question. So I know there are lots of platforms and apps to quickly register for a Delaware C-Corp online. promise you to take like less than a day and then under $500. Would you recommend that approach, or how different is that compared to actually consulting a corporate lawyer?
That's a very good question. I mean, for 500 to set up a company, they usually do very limited work. For example, they just file the certificate to help you to get the EIN. Some of the websites, they actually get more. For example, they even get the founders restricted stock purchase agreement, things like that. The form, if they offer that, usually they are tailored for startup. It's okay to use. The difference is that you short of your coach to coach you. So there's a lot of you have to do the self-study, and later on, for example, especially the founders restricted stock purchase agreement, there's a lot of mechanism. For example, when the company exits, like how your shares be accelerated, and when the founders have a death or disability, or they even being kicked out by future board, how their shares are going to be dealt with. So there's a lot of details. If you wanted to have a person to talk to you, probably you wanted to hire a law firm. And frankly, I think a lot of law firm offer package for startup, so it's not much more expensive. Personally, I think you can make your choice. If you're really in an urgent, you really tight on budget, it's okay to use those online form that provide you also the restricted stock purchase agreement. I won't recommend any online platform only file your certificate, because without the internal documents, it's not properly set up. Plus, one thing is, if you have a shareholder that is foreign, remember you have some additional compliance requirement. For example, the Department of Commerce, they have the certain filing requirement like BE13, and those startup platform, they don't usually take care of those circumstances. They typically for startup only here, and all the shareholder are the US people.
Yeah. Got you. Yeah, thank you. So Kenny asks one more question. Does the company usually cover the fees of filing 83B, or is it typically filed by the co-founder or early employee themselves out of their own pockets?
Most of the law firms will recommend the shareholders make their 83B itself, but they're going to prepare the form. They're going to give you the cover letter, they give you the form, and so you fill it out, because law firm, they don't want to tell you this is a fair market value. There's a legal issue involved, but they can give you the form. So you fill it out, and then you mail it to the IRS. Usually you mail 2 copies at least, so that IRS, they're going to retain a copy and then mail you back a copy as evidence. And also you wanted to keep that evidence on your file. Which is very important.
Yeah.
But by the way, the cost is nothing. It's milling fee, so it's not really a cost.
Sure. I guess if we have 5 minutes left, so feel free to ask more questions if you guys have any. And if you guys are having more nuanced conditions, or you want to personally consult Ms. Liu, feel free to scan the QR code under the screenshot on the page, and add Ms. Liu's personal WeChat. And if you want more content like this, Founder Coho will be launching other series in the future. You can follow the LinkedIn or YouTube channel of Founder Coho. Yeah.
Thanks.
Yeah, thanks everyone for joining. If you don't have any questions, feel free to leave. And okay, we have one question from Raymond. What's the most recommended form of corporation?
I mean, for venture financing, probably C-Corporation. If you're doing a business, for example, you set up your own restaurant, do a small business yourself, and you're living in the US, LC is probably more favorable, because the company doesn't have really any tax, and you are the owner, so you only need to report the tax together with your individual other income. So it's tax-wise, it's more beneficial.
Yeah, I would say like if you want to ask questions, then it's always the best to keep it more specific. So maybe tell us a little bit about your situations and your preferences, so Ms. Liu can help with her most knowledge.
Yeah, also because of timing, I can touch upon a little bit of the topic I didn't really finish. It was regarding the preferential rights. So the most important is liquidation preference. So in Silicon Valley, we do liquidation preference is 1x plus non-participation, which means if the company got an exit, the investor can choose whatever is more beneficial to them, either to have the company return their investment, means 1x. You can also do 2x, means return twice of your investment. Or you can choose to non-participation. That means once you choose to get your investment back, then you cannot participate on the rest of the allocation. But when the investor gonna ask, if I only get my money back, why I even invest it? Because you have another option. If you don't want to choose 1x, you can choose to share with all other shareholders based on your share percentage of the profits. So whatever is more beneficial to the investor. But the good thing for the investors, they got the money first. So this is to protect the investors' money, because you got the money in the company, and the founders was more like a sweat equities.
Yeah, we have 2 more questions to go. I think those 2 are the last one. So Raymond asks, for Delaware C-Corp, I think there's a typo there. He probably said Delaware C-Corp and S-Corp, or Delaware C-Corp versus other states Corp. Which one is better for a tech startup?
A tech startup? What mean
Yeah.
tax startup?
I think technology startup.
Okay. I mean, Delaware is mostly common use. I won't say like Delaware is, because no one really do a thorough comparison line by line on the state law. But Delaware was commonly used. It's because of the years of accumulation of everybody's practicing it. All lawyers are familiar with it. If you set up a company, for example, in Nevada or in Oregon, the lawyers may not really familiar with their local law terms that cost you more legal fees too.
Yeah. Last question from Asimix. Is J1 visa for interns advisable to use?
Sorry, it's J1. That's more, I would suggest you and check with an immigration lawyer, because it's not really my field.
Yeah.
Hmm.
Okay. Yeah, I think we are out of time, so that will be it. Thank you for everyone who attended, and thank you so much, Ms. Liu, for giving us this informative presentation. I saw lots of thank yous in the chat, so thanks so much.
Thanks everyone. It's my pleasure. Thank you, Jack.
Yeah, thank you. Yeah, bye-bye, everyone.
Bye.